I got a new client just a little bit ago.
I can't paint clothes until Friday.
Wow.
Because of the weather.
Yeah.
Look on Google and see what time Friday morning. You do that?
Thank you. On group me?
Yeah. I got Google on it.
And go do that again. Get updates. I bet it's even more now. But see, when you have that information, these are the things that any of these corporate, I don't care who they are, city council,
All right. Yeah.
It shocks them. They don't say that.
And since it said that we are the employers,
Right? They have to answer to us.
exactly. Have to put their feet on fire.
Friday.
I'm ready when you are.
Okay, so this is about what?
Huh?
Let's see what time it is. It's,
I have 154.
you got about an hour.
Wow. Oh, wait here. No, that's Saturday.
Do we have Eric with you still?
No, Ken kicked him off.
Well, they're starting now. June 7th, 2025. That's just the election. Yeah, so there's nothing.
He was.
Today.
Denise is asking who is Jesse. You know who Jesse is, right? How do I answer that question?
He was on the call. Very nice.
He was on a couple of our calls.
Two different.
He would remember.
There's actually company on accidentally.
Yeah, I think we'll get in there before we get started.
Okay, so we ready to go?
Just we're calling Eric real quick to see if we can get him on.
Well, I have a live stream on YouTube. He can go to my live stream on YouTube if he wants to. It's live streaming on YouTube.
Did you get his virtual on Skype?
I texted him.
Tell him there's Sovereign Living. It's a live stream on YouTube. My channel is Sovereign Living.
Text it to him at the live stream representative.
Going on.
I slept like the dead. When I woke up, when I stood up, I wandered up, came out, and I said, oh my God, I must be having possible cause. I walked with the guy. my secretary and I were
Anything back?
doing something, because somebody would be back from work. And then we lost it.
Thanks for trying anyway.
Okay, well, let's go.
Okay. Glenn's gonna start down on his 12 presumption that he's against us.
He's in the waiting room of the Supreme Court.
Okay.
Eric,
All right, everybody, let's have a good hand for Glenn to come talk to us again.
can you tell Eric?
I'll introduce.
Oh, okay.
Ladies and gentlemen, we have a very, very special guest today.
Tell them again the live stream.
Some people know him as a sovereign citizen, but we know he's not that because that's an oxymoron. Everybody give it up for Glenn!
Thank you. Okay, so this is I got to give, all of my stuff. There's very little of my stuff that I come up with on my own. Usually I get someone else's stuff and massage it, and this is a good example. This is Heidi's mandatory judicial notice of 12 presumptions.
How about being respectful and being quiet?
Oops, I'm sorry, I apologize.
Thank you, Mike. Anyways, this is Heidi's mandatory judicial notice of 12 presumptions that I modified. I have to give Heidi credit for it because it's brilliant, and I saw how brilliant this affidavit of life is brilliant. She's got a lot of brilliant material. So this is the mandatory judicial notice of 12 presumptions. It starts off, BAR is an acronym and stands for British Accredited Regency. I don't know how many of you know this. This is a friend of mine in Canada that told me this, and it just makes a lot of sense. I haven't found anything that confirms this, but this just makes a lot of sense. Regents, an office or jurisdiction of a region or body of regents, a government or authority by regents, period during which a regent or body of regents governs. And it's all coming from the UN, actually from the Vatican. Because all bar members are appointed by Inns of Court, right? This is, there's certain private unincorporated associations in the nature of collegiate houses located in the City of London and invested with the exclusive privilege of calling men to the bar, which is located in the Pope's owned and operated City of London and Kingdoms of England and Ireland, now known as United Kingdom, and the Crown, since the concessions of England to the Pope, 1213, and where it says will establish perpetual obligation and concessions, will establish that from the proper and special revenues or aforesaid kingdoms for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling. So because King John gave them to the Pope, did you know that? He gave them to the Pope and agreed to rent them back for 1,000 marks sterling a year. And this is taken from Tomlin's Law Dictionary, Volume 2, 1835 edition, under the definition of Pope. Says, and not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III, and received them again, and hold them of him under the rent of 1,000 marks. So the Pope, he gave them to the Pope and rents them back, which means that all bar members are foreign agents of the Vatican, which is why they're here under the foundation of the Federal Bar Association, located in the code in the Title 35 of the U.S. Code 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945, that's at 59 Stat 669, and the Pope's owned and operated United Kingdom and the Crown created the Cestui Que Vie Act of 1666, This is Tomlin's Law Dictionary again. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use, and the receiving the profits, while the season of the land remained in the nominal fief who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. Isn't that convenient? They get to decide whether it's real or not. Eh? How convenient. To be bound in conscience to account to assesticate use for the rents and emoluments of the estate. Well, think about it. That's taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. So, and a use, when they're talking about a use in here, that's a usufruct, which was brought into America first with the unconstitutional 1871 municipal corporation at 16 Stat 419. Civil law, and Roman civil law are convertible phrases being the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. And then with the Code of Law for the District of Columbia in 1901, and where it says the legal estate to be necessitate use at 31 Stat 1432, which is now codified at 31 CFR 363.6, and are unconstitutional because municipal law is the law of the dependent papal ecclesiastical states. This is Encyclopedia Britannica. You know, it's really hard to talk with people chattering over here. Civil or municipal law, which every sovereign kingdom or state has appropriated to itself. The appellation of municipal was originally confined to the laws of the municipia, or dependent states. Those were ecclesiastical city-states in Italy. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, between Tuscany, Modena, and Lombardy in the northwest, and Naples on the southeast area. 17,822 square miles, population in 1833, 2.7 million. Capital is Rome, population 153,000. Government, an elective monarchy, the Pope, for the time being, the absolute sovereign, with a consulting assembly of cardinals. And that's Waterston Encyclopedia of Commerce and Mercantile Law, 1863. Rome is the capital of the Pope's territories and of Italy, and anciently the Milrus of the Roman Empire. And it's also called canon law. Civil or Roman and canon law, though they are not perhaps to be deemed proper parts of our written law, have undoubtedly had the greatest influence in Scotland. So this is Encyclopedia Britannica, or New Dictionary of Arts and Sciences, 1771. So this was published in Scotland, obviously. The power exercised by our sovereigns and judges have been justified upon no other ground than that they were conformable to the civil or canon laws. And a special statute was judged necessary upon the Reformation to rescind such of their constitutions as were repugnant to the Protestant doctrine. From that period, the canon law has been little respected except in questions of tithes, patronages, and some other few articles of ecclesiastical right. So the Vatican kept a little finger in there. But the Roman continues to have great authority in all cases where it's not derogated by statute or custom, or where the genius of our law suffers us to apply it. This is Encyclopedia Britannica, or New Dictionary of Arts and Sciences, 1771, which is now the Vatican, and unconstitutional because of Article 1 and Amendment, Congress shall make no law respecting an establishment of religion, and is unconstitutional because this is what precipitated the War of Independence. And this is cause of necessities for taking up arms, 1775. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. Well, so you have a government that's established by charter, and all of a sudden Roman law is running everything. That's like major change. We saw the misery to which this despotism would reduce us. That's dictatorship. And the organic law, the Declaration of Independence, was listed as the reasons for the Declaration of Independence from the Pope's tyrant. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses. Now, that could have been because they were taking them to England to put them on trial, but it could also be talking about the Sesta-KV Act of 1666. Imposing taxes on us without our consent, that's certainly talking about the Sesta-KV Act of 1666. For depriving us of many cases of benefit of trial by jury, for taking away our charters, abolishing our most valuable laws. He's abdicated government here by declaring us out of his protection and waging war against us. And he is combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, can only be talking about the Pope's Roman law. And the minor estate is an entity because an entity includes the estate of a living person, such as an incompetent or a minor. And a minor can be anyone over the age of 18 years who has failed to take control of securities in the Treasury direct account.
Can you make it bigger?
Is that better? I got to see if it's coming through decent on YouTube now.
Yeah, that's nice. That looks much better.
Yeah, it's coming through on YouTube now too. Okay. So the minor estate is a fiction of law which was invented by the Roman praetors under the pretense of doing equity. This is Bouvier's Law Dictionary, 1856 edition, page 520. Fictions of law. Fictions were invented by the Roman praetors who, though not possessing the power to derogate the law, were nevertheless willing to derogate it, who not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity. Fictions of law owe their origins to the legislative usurpations of the bench. So think about it, legislative, it's legislative. Fictions of law owe their origin to the legislative usurpations of the bench, which is necromancy, and it's satanic. This is Deuteronomy 18, 10 to 12, King James Version. There shall not be found among you anyone that maketh his son or his daughter to pass through the fire, that useth divination, or an observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, and because of these abominations the Lord thy God doth drive them out from before thee. Which is also a bill of attainder, because a bill of attainder is a legislative act that applies to named individuals to inflict punishment without a judicial trial. Well, the judge is in bad behavior, so then he's not a judge, right? And it's a legislative act. It already told about how it was legislative usurpations of the bench. Bill of attainder, legislative act, no matter what they're formed, apply to either named individuals, okay? So in other words, in order of commitment for you to go to jail, that's to a named individual, in such a way as to inflict punishment on them without a judicial trial. It's not an Article 3 court. Bill of attainder is a special legislative act prescribing punishment without a trial for a specific person or group. Bill of pains and penalties, a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So they're bills of attainder is what they are. And prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And also Article 1, an amendment, which says Congress shall make no law respecting an establishment of religion, because it's from the Pope's Roman law and also known as canon law, and because they have imposed martial law rule. And that's caused the necessities for taking up arms again, with the bankruptcy emergency. Okay, so it's an established fact. The United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental officers, and departments, and as further evidence that the United States federal government exists today in name only. And that's congressional record. So notice that March 9th, 1933. Since March 9th, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in plethora particular ways control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's U.S. Senate Report number 93-549, dated November 19th, 1973. Do you think anything's changed? Absolutely not. Because martial law rule is the law of emergency and necessity. There's three kinds of martial law. Full martial law is when you're actually invaded by a foreign enemy or there's an insurrection and troops are put on the street. Martial law proper is the law of the armed forces when a sergeant tells a private what to do and it's enforced by court-martial. And martial law rule is the law of necessity and emergency. It's used during peace times and can go on indefinitely. And that's taken from Ex parte Milligan, U.S. Supreme Court. And the Pope's bar members on the bench tell you I can do anything I want. And this is taken from this non-ratification of the 14th Amendment by Judge H. Ellett of the Utah Supreme Court. He says here that this is a war over the intrusion of civil law upon the common law. The Court of Diamond v. Harris calls the civil law, statutory law, superior equity. It is difficult to see, and this is a quote from the Diamond v. Harris case, Texas case, it's difficult to see how the courts of this state are to ignore the common law as a rule of decision when it's made so by statute and adopt a civil law even though it had the merit of superior equity. In the meantime, civil law was a form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. He's talking about common law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law. thereby destroying the common law and leaving what's called equity in its place. Because under martial law rule, equity does not follow the common law. Every system of law known to civilized society generated from or had its component one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we would dissolve domestic frictions and the rule by which all legal controversies are settled, which makes it satanic. And the Pope, the Vatican, now owns and operates the bankrupt 1871 corporation, as evidenced by the Roman Achaia military staff that's planted on all conquered nations, that's sitting on the right side of the Speaker's podium in the U.S. House of Representatives, and the two Roman fascia, which is a bundle of rods bound into a weapon symbolizing subservience under the rule of a single man, that are on the wall on each side of the Speaker's podium in the U.S. House of Representatives. And this is the apostolic letter entered into force on the 1st September 2013. That was Frank's, Francis. They call him Francis, but I don't like him, so I call him Frank. It was Frank's first letter. When the same matters are prosecuted in other states, the provisions in force in Vatican City on concurrent jurisdiction shall apply. So this is about criminal matters. And the Pope's satanic bar members are assaulting people with their Roman fiction of law, minor estate, 31 CFR 363.6, which is a cestike use, which is a usufruct, or a trust, which is necromancy, with the following presumptions that are rebutted. So all that stuff I added in. This is the stuff that Heidi had put, which is very good, in my opinion. The presumption of public record is that any matter brought before a court as a matter for the public record, when in fact it is presumed by the members of the private bar guild, which is what they are, is a private bar guild business matter. This presumption is rebuked and rejected and is hereby demanded the matters to be on the public record. Number 2, the presumption of public service, that all members of the private bar guild who have sworn a solemn absolute oath to their guild and then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oath to their own guild. This presumption is rebuked and rejected. The claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. The possibility of this matter being a private matter is rebutted. All members engaged in the matter at hand are deemed to be public service, in the public service as public servants. The presumption of public oath is that all members of the private bar guild acting in the capacity as public officials who have sworn a solemn oath, public oath, remain bound by that oath and therefore bound to serve honestly, impartially, and fairly, and dictated by their oath. It is openly challenged and demanded that the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. It is openly challenged that such individuals must recuse themselves as having a conflict of interest and cannot stand under a public oath. The possibility of this is rebutted, and all public servants acting on behalf of this matter are required to state all sworn oaths, both public and private. The presumption of immunity is that key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn the public oath in good faith are immune from personal claims of injury and liability. It is openly challenged and their oath demanded. The presumption stands that the members of the private bar guild as public trustees acting as judges, prosecutors, and magistrates are immune from personal accountability for their actions. This is absolutely rebutted. Any person acting as an agent for a nameless, faceless corporation is wholly personally liable for their acts on behalf of the corporations. All actions incurring any degree of injury will incur notice of liability, including severe financial penalty. The presumption of summons is that by custom, a summons unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons, unless the summons is rejected and returned with a copy of rejection filed prior to choosing to visit or attend. There's a friend of mine in the Republic of Texas that did exactly that. He rejected their summons and the case disappeared. Jurisdiction and position as the accused and the existence of guilt stands. This presumption is absolutely rebutted on this occasion, on past occasion, and all future occasions. However, at no time was I absent nor silent with regard to the matters at hand. The presumption of custody is that by custom, if a summons is not rebutted, it stands as therefore one who attends court is presumed to be a thing, and therefore liable to be detained in custody by custodians. Did you guys know that? Anything in jail is a thing. There's no people in those jails. It's things. Actually, they're called slaves. Slave is a thing. Anyways, custodians may only lawfully hold custody of property and things, not flesh and blood soul possessing beings, unless this presumption is openly challenged by a rejection of summons or at court, the presumption stands you're a thing and property and therefore lawfully able to be kept in custody by custodians. This presumption is absolutely rebutted. I'm alive and well and a man. I'm not in custody by custodians or guardians. I'm not a thing. I'm not property of the court. Under no circumstances may I be detained in any way whatsoever, not at any time in the past, present, or future. The presumption of the court of guardians is the presumption that you may be listed as a resident of a ward of the local government area. You're a pauper and therefore under the guardian powers of the local government and its agent as a court of guardians. Unless this presumption is openly challenged to demonstrate you're both a general guardian and general executor of the matter before the court, that's a trust, right? That's involving a trust. Before the court, the presumption is rebutted that I am by default a pauper, a lunatic, and therefore must obey the rules of the clerk of guardians, the clerk of the magistrate's court. This presumption is absolutely rebutted. I am at all times a man, sui juris, and have possession of much more than 21 silver eagle coins with a face value of $1, and therefore fail to be a pauper. That's stuff I added in right here. Anyways, the presumption of the court of trustees. Okay, this is all trust law that we're talking about here. This is all trust law. The presumption of the court of trustees is that members of the private bar guild presume you accept the office of trustee as a public servant and government employee just by attending the court. As such, courts are always for public trustees by the rules of the guild and the court. Unless this presumption is openly challenged, you state you're merely visiting by special attendance to clear up the matter, and you're not a government employee or a public trustee in this instance. The presumption stands and is assumed as one of the most significant reasons to claim jurisdiction simply because you appeared. The presumption is absolutely rebutted. Absolutely no jurisdiction at any time may be claimed by the private bar guild and the court over me. The office of trustee is rejected. The role of public servant and government employee is rejected. I'm entitled to common law, not Roman law, as described in Article 6, Clause 2 of this Constitution for the United States of America. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. Because law of the land phrase is a convertible phrase with common law. The principle that no person shall be deprived of life, liberty, or property except by due process of law did not originate in the American system of constitutional law, but was contained in the Magna Carta. sometimes referred to as Chapter 29, confirmed on the 19th day of June 1215, because King John gave his kingdoms over to the Vatican, to the Pope, and they had imposed Roman law in England, and the Magna Carta was the result. Declared. And the Magna Carta is full of this kind of stuff, saying that you can't do your Roman law here. No freeman shall be taken or imprisoned or seized or outlawed or exiled or otherwise destroyed, nor shall we go upon him nor send upon him but by the lawful judgment of his peers or by the law of the land. It has even been said that the principle was known before Magna Carta and is originally designed to secure the subject against arbitrary acts of the crown and to place him under the protection of the law. It is settled beyond question that this principle came from England to America as a part of the common law and has been a fundamental rule in common law. When first adopted in the Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule in common law. The presumption of government acting as two executors. The presumption, this is 9, the presumption of government acting in two roles as executor and beneficiary is that for the matter at hand. The private bar guild appoint the judge/magistrate in the matter in the capacity of executor, while the prosecutor acts in the capacity of beneficiary of the trust for the matter. Unless this presumption is openly challenged to demonstrate you're both a general guardian and a general executor of the matter, the trust before the court, the presumption stands and you are by default a trustee, therefore must obey the rules of the executor, judge/magistrate. This presumption is rebutted. I'm a man, and your minor estate was created by fraud and deception by the Pope, and the Pope's owned and operated Crown of England created the Cesta KV Act of 1666, and I require that the minor estate be dissolved and liquidated immediately. And I don't care what you do with the fake money in the Treasury direct account, because you can put it up your rectal orifice for all I care. But I demand that it be dissolved and liquidated immediately. The presumption of executor de sans tort, that's number 10, is the presumption that the accused does not seek to assert their right as executor and beneficiary over their body, mind, soul, living man. They are acting as an executor de sans tort, or a false executor, challenging the rightful judge as executor. Therefore, the judge/magistrate assumes the role of the true executor and has the right to have you arrested, detained, fined, forced into a psychiatric evaluation, unless this presumption is openly challenged by not only asserting one's position as executor, as well as questioning if the judge or magistrate is seeking to act as executor de sans tort. The presumption stands. This is all trust law. And a judge or magistrate of the private bar guild may seek the assistance of bailiffs or sheriffs to assert their false claim. This is rebutted. Under no circumstances may the judge attempt to assume the role of executor before any personal attendance before the court is undertaken to discuss the matters at hand.
Hey Glenn, especially for this portion here, it reminded me, for anybody who copied that court paper and intended to use it, when that trust was turned around, one of the things I think would be beneficial to put in there is to release any other surety, because there was no statement regarding the surety, which is the capacity you're being held as the thing, right? So when you're defining these relationships as to who's the executor, who's the beneficiary, and what those roles are, if you're using that document in court, I think it would be very beneficial to make sure that you've moved out of the position also as the surety held in addition.
Okay, so I see your point, but what my argument is that it's a fraud and a nullity. Okay, the whole thing's a fraud. But what I can do is I can address the issue of the surety and say there is no surety in this matter.
And I think that's essential, because I look like in my case, like I didn't have to pay the fine. They left me alone after the execution. But the bottom line is I was still being held as the pawn ticket surety, waiting to be claimed. And I would have defined that better, there may have been a different outcome there.
That's a good point.
Yeah, that's a very good point. Matter of fact, I think I'm going to put it in there in a couple places. I'm going to move up to this other one here.
Because I think, it's one thing to define the financial relationship, which is the only part they care about. But what we care about is our physical body that's being used in the process. And I did not define that in the trust and should have.
Yeah, I think I mean, what you did here is brilliant. And that's a really good point. I've just added it in a couple places. Because if it's a fraud and a nullity, then there's no surety by definition.
And I presume that based on the claim of fraud in the claim by the third-party intervener, but I just think there's so much trickery. The more we spell out plainly,
Absolutely.
it makes it hard for
Yep.
the judge in the role of trustee then
Absolutely.
not to execute on that, because their last questions to me, do I have anything else to say?
Yeah.
My answer was, set me free. That's the only thing I should have to say.
I would have said, release me.
Well,
But anyways, yeah, that's a great point. That's a great point. I love that. And because even the Bible says you're not supposed to be surety for someone else.
correct. That's correct.
And
So addressing the surety issue, like I said, I mean, there's lots of things that learned in hindsight, but for anybody who is tempted
Yeah.
to use that paperwork, I would think about,
that's a great point. And I've added it in here twice. There is no surety in matter. Because it is a fraud. And a nullity. Anyways, I want nothing to do with your minor estate or your Roman law / canon law and consider it satanic and offense before God. You can put it up your rectal orifice. The presumption of incompetence is the presumption that you're at least ignorant of the law, therefore incompetent to present yourself and argue property. Therefore, the judge / magistrate as executor has the right to have you arrested, detained, fined, or forced into psychiatric evaluation unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to any contrary presumptions. Then it stands by the time of pleading that you're incompetent, then the judge and magistrate can do whatever they need to keep you obedient. This is rebutted. The law is under scrutiny for its contribution to the current state of the planet, the distribution of rights and resources, and obstruction of divine law. In discussion regarding such matters, no privileges or deeming us incompetent is permitted. This is all the Pope's Roman law / canon law and unconstitutional as described herein. The presumption of guilt is the presumption that it was assumed to be a private business. This is the last one. Meeting of the bar guilt, and you are guilty whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of trust and motion to dismiss with extreme prejudice on the public record or called demurrer, then the presumption is you're guilty, and the private bar guilt can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. This is rebutted. Under no circumstances is the presumption of guilt allowed, as I am the redeemed property of my Creator, forgiven of all sin. I'm a living man. And then I basically made it, this is stuff I added at the very end, signed and sealed in red ink on the land under penalties with perjury without your Vatican corporation, 28 U.S.C. 1746-1. And then it's my normal just statement at the very end. Anyways, this was really good that was done by Heidi. And it's got some great stuff in here. I think that what I'm going to record a copy of this. I'm just debating about whether I want to print it and get a bunch of witnesses to sign it for my signature, witnessing my signature. And I'll probably make a few. I went and sent Ken a copy of it here last night, and then I made changes to it afterwards. And so, I'll probably tweak it and adjust it. I like the idea of saying there's no surety because the whole thing's a fraud, and so and then you might even add in something about the affidavit of life. That affidavit of life, I'm going to record it in Pinal County in Arizona when I go there next, and then after 30 days it becomes public policy. And I'm also going to file it. One of these is going to get filed into the federal court here in Fort Worth. I'm sure. Jason showed me he'd done something similar. When did you do that anyways, Jason?
When did I do the recording?
Yeah.
It's been about a year and a half ago.
Right. That's probably why they're not messing with him.
Okay, and I was going to tell Heidi was asking me the location. It's 1700 Guadalupe Street at the Family Court in Austin will record living people documents.
Yeah, that's interesting.
They charge a fee, but they'll record it.
Yeah, it doesn't matter. I mean, the fact that it gets recorded in any court into the public is the important part. Yeah. Now you can actually, some of the county clerks, like I've heard the Cook County, you can record anything in Cook County. I know that down here in Tarrant County, they give you a hard time. I know in Arizona, they told me that they'd record a hamburger if I took it in there and paid the money.
I can't tell you, we've done criminal complaints at the place in Fort Worth at the old courthouse, right there with witnesses. All right, and everybody comes sign the criminal complaint right there that we witnessed them not recording this document, and dude, they don't give a crap. Yeah. I did have some luck, and I recorded a power of attorney of my mom assigning my birth certificate from the registration back to me, and I did have some luck with that. I can't believe they recorded that, but.
Yeah. So, anyways, this has got Eric's on YouTube. He's shown up on YouTube under his son's account. Anyways, these a lot of the arguments that I'm going to use when I do the Rule 11 petition to the Supreme Court. I still think I'm going to do it. Right now, I'm waiting. There's a thing in the Court of Appeals for the Fifth Circuit. I'm waiting to see, because I have an appeal in the process there, so I'm waiting to see what they do with what's going on there. But I'm still thinking about doing our Rule 11 petition. Rule 11 is an emergency petition, and the criteria is it's got to have national significance. Well, it would certainly have national significance, of all these municipal corporations that are set up, like thousands of them all across the country. If they were deemed to be unconstitutional, then but you see Gorsuch complaining about this administrative law, and there's some of the judges that come out openly against the administrators, the judges dressed up as administrators. They use those kinds of comments and stuff in their cases. So some of them would go for it, but whether we can get enough to actually have, we'll see. You got to give it a shot, anyways. And remote viewers saw Congress adjourning for the last time. That would certainly be grounds for Congress to adjourn for the last time, because they're unconstitutional. You see what I'm saying? And so I don't know if they'll take it. I got to give it a try anyways, and we'll see what happens. And anyways, I don't see any questions here on YouTube. If anybody wants this file, send me an email. I'll if enough people bug me about it, I'll probably upload it to Google Docs and put a link in below the YouTube video. But don't send me an email telling me you want access to the file, okay? Because I don't give access. What you do is you download the file. You can download it on your hard drive, and then you can manipulate it and do whatever you want with it, okay? I do not give access. There's not going to be anybody manipulating that file in my Google Docs, and so forget about it. But you can download the file onto your hard drive and do what you want with it. Anyways, I suppose that's about it. Does anybody have anything else?
Well done.
We got about 15 minutes for any kind of questions.
Yeah, so if anybody's got any questions, we can answer some questions.
What's the name of that document that you're reading?
It's a mandatory judicial notice of 12 presumptions. Yeah, that was one of the documents that Heidi did, and it's just brilliant. There's a bunch of that stuff that Heidi's done that's brilliant. I've known about this stuff. Like, I have a document about presumptions. I've got a YouTube video about it, but they're different presumptions. They're not like this. And then the affidavit of life. I mean, that one, I've been thinking about doing that for a long time. I just didn't know how to do it. And so that one was brilliant too. And the fact that your thumbprint and your own blood is on there. Anyways, I just got to twist Joe's arm to take some blood so I can have something to put a thumbprint with. Yes.
So actually put the blood on the document?
I did, and I did it.
I heard they could deem that as
A biohazard?
Yeah.
You know, whatever. I don't care. I'm going to put it on there.
You can laminate over the front and back of that,
Oh,
and
okay.
it's still retrievable.
Because that's what I wanted to do
Yeah,
was blood.
because when they capture
You know.
us, they will happily take your DNA, and I think
Yeah.
you have to have your blood in order to authenticate your identity, because that's the standard they're holding you to.
Yeah, and if you file it into the court, okay, they keep the original. They put it in their file. They give you a copy. And so you know, and what I want, actually, I was going to tell them I want a certified copy.
Yes. So the laminate will be able to be copied?
I actually did not laminate mine when I filed it in the county. They took it as is because they were probably sleeping on the job, which I count on. And so the same way when I filed in addition, what I refer to as an archetypal state, created my own state, and made my own affidavit about who I am, what I believe, and then with my signature, same blood print on that, and most silly Secretary of State office is happy to take that too. So anywhere I can get that in, I'm happy to do that, because then they're subject to pulling it back out, because that's the same database they use to identify you with their pirate vehicles when they're flying around on the streets.
Absolutely. So that's why I'm not gonna laminate it, quite frankly. I'm just gonna do it, and I'll bet you they'll take it no problem. You know, if it becomes a problem, I'll deal with it at that point.
Yeah, I had a lot of other distractors on the stuff I filed at the federal level. You know, I had the emblem for my family arms. I actually made a stamp with my family arms, which became my stamp. If I don't see that stamp on my signature when I'm submitting those documents. So I have lots of things for them to look at, and I don't know that they paid attention to all of them. In addition to the stamps.
They don't. I'm gonna tell you now, they don't.
Okay, Steve has a question.
I was thinking, instead of laminating it, just put a piece of boxing tape just over the thumbprint front and back, and just claim that's to avoid any biohazard concerns.
You know, again, what I'm just going to put it on there. I mean, it's going to be dry by the time. The only time it's really a biohazard is if it's not dry.
Well,
But-
if I tape it, it might avoid access to the DNA.
Well, you go ahead and knock yourself out. I'm just going to take it in there and record it, and we'll see what happens. I'll deal with it if they don't want to accept it. You know, but those are all good ideas. Those are good ideas, so we'll see. You know, that's all I can say. Yes, Carrie.
Okay, what I did was I told him, I said, okay, I want a doctor to tell me if this is a biohazard, and had him sign it.
Oh, there you go. That's a good idea.
I mean, that way it's, okay, that's a biohazard, but the doctor said it wasn't. So now they've got to come past me, and then they got to come past the doctor who said it wasn't.
Right.
So I want everything, I want it spelled out.
Yeah, well, that's a good idea.
If they took my blood at the clinic, they probably have my DNA anyway, right?
Well, I understand that, but what they're gonna say is, well, you're a biohazard, yet the doctor here said it wasn't. So if the doctor said it wasn't, and he's an attorney, who's here now? See, now I'll break it when I can.
Right. Yeah, exactly.
Any questions online before we close out?
Well, he's actually Tim said that or Eric, I should say, said he wants me to call him. So I'll probably get his phone number. You got it, Steve?
Gotcha.
I'll probably get it and then call him. I'll text him first.
It'd be $5.
$5. Yeah, so Eric, Steve is going to charge me $5 to get your phone number. I don't think you want to put it in the chat on YouTube.
I'll give it.
Oh, now all of a sudden he says he's going to give it to me.
For $5.
He did what it is. You know what it is? He's a politician.
There you go. Anyways, so I guess that's about it. This has only been 54 minutes, so that's about the right time. It's about the right time, and so we're going to go ahead and end it. Thanks everybody for watching. I'll text Eric once later on today probably. And here.
Anyone that wants to go with me